Seated. Next case on the calendar this morning is Sheraton Bal Harbour Associates versus Department of Revenue. We've allotted 15 minutes to decide.
Good morning, Your Honors. If it pleases the Court, my name is Joe Maffa. I represent the appellant, Sheraton Bal Harbour Associates, in this case. If I may, I'd like to reserve 3 minutes for rebuttal at the end. This case basically comes down to 3 words in a statute. The words are when such charge occurs.
Well, I guess you've already seen, if you watched the first case, that words maybe don't always mean what they first appear to mean.
Actually, many of these cases they were citing and many of the concepts that you folks were discussing were very appropriate for this case, Your Honor. In this case, the taxpayer, the Sheraton Bal Harbour Associates, had filed a refund claim for gross receipts taxes paid on telecommunications charges that they charged to their hotel guests. The statute, we believe, is clear and unambiguous. It states that charges, here, let me read it to you. Charges made by hotels and motels which are required under the provisions of Chapter 212 to collect transit rental taxes from tenants and leases for local telephone service or toll telephone charges when such charge occurs incidental to the right of occupancy in such hotel or motel. The Department of Revenue had issued a rule which recited exactly the same language, but then it went on in paragraph B of the rule and stated, however, charges that are separately stated cannot be incidental to the right of occupancy. We believe that they've ignored these 4 key words in the statute, which are in the last sentence of the statute.
Counsel, what is your interpretation of those key words, when such charge occurs, incidental to the right of occupancy?
When it says when such charge, it's indicating that there has to be a charge that's going to occur on a hotel bill. That's what they mean by the right of occupancy. So for the statute, under the clear, I believe the clear meaning of the statute, when such charge occurs means that there has to be a charge. And in the rule, when they eliminated the requirement that there be any charge, that if a charge is separately stated, they've in effect eliminated these 4 words of the statute. If you compare the rule and the statute, and compare them precisely, if you took these 4 words out of the statute, the rule would be perfect. But when you add these 4 words to it and compare it, that's where the problem comes in. Judge Lewis, you in a recent case in the last year, in the Lockheed case, had a very interesting analysis of two sentences in a statute, where you indicated, in that case, the issue came down to some words that preceded the words in research and development. And in that case, it was used directly and solely, and the second sentence had used the word employed. And in your decision that you wrote, you indicated that you should give full effect to all statutory provisions, and you separately defined those 2 very closely related terms. And I believe it's exactly the same situation in this case. We have some provisions in the statute, and it's those 4 words, when such charge occurs. And again, if you go back and you compare the statute and the rule, if the rule would work perfectly if those 4 words weren't there. It's because these 4 words in the statute, they're basically making them meaningless. The whole intent of this...
What does the last phrase mean, incidental to the right of occupancy in such hotel or motel?
To me, it means that you would have to be that you have to have a hotel tenant or a guest.
So whenever you're in a hotel and there's a telephone service charge involved, it falls within the statute.
Only if you're a guest. If you have a payphone outside, or any other charges by a hotel.
Well, sure, but it's not intended to cover payphones.
But if it wouldn't have
had
that limiting language in there, it could have covered many other things. That's why I believe that the limiting language was put in there. The whole purpose of 203 back then was a gross receipts tax for utilities. Hotels and motels are the heaviest taxed industry in this state, and they in effect were.
And they pass it all along to the customer.
On the sales tax side, that's correct. This was a gross receipts tax, and it was a little bit different. In this case, they did not pass it along.
You build it into your rate.
You may build it into your rate, but they also were paying gross receipts tax on the telecommunications service charges that they were buying. So what they attempted to do with this statute was allow them not to have to pay it on one side and then get a credit on the other side. They said, hey, if it's if it's charges, when such charges occur incidental to the right of occupancy, we will not treat you like a utility company and require you to remit gross receipts tax.
Tell us what about the department's interpretation of that statute is unreasonable, other than that you think that they're reading those 4 words out?
Well, I think it's clearly erroneous, but here, if I may, I'll just read it to you because it's very short. It says, charges to customers by hotels and hotels for the use or access to telecommunications services are not considered incidental to the right of occupancy when such charges are separately stated, itemized, or described on the bill, invoice, or other tangible evidence of the sale of the service. Again, going back to the statute, on the
now you're equating charge with bill, right? Charging and billing are the same in your mind.
There has to be some tangible element of a charge, yes. So if it's a bill or a credit card receipt or
and
whatever.
It has to be separately charged, or any way you charge it?
Well, there has to be some evidence that there's a charge. And if you don't charge someone, there is no charge.
Well, what if, for instance, like many hotels now do, instead of charging $1 a call for local calls, they have no charge for local calls. They just build it into the nightly room rate.
Well, if this statute would still be in effect, which is no longer, there would be no issue because they didn't charge for that.
Well, sure they did. They just charged it as part of the room rate. They built it in.
But how would you allocate the cost of a hotel room then? Would you have to, for gross receipts tax purposes, there would be no way to allocate that charge. You have to have some evidence showing what the charge is for the phone call, for the long distance call, or for the local call. And that's the whole problem with the rule. The statute's very clear. When such charge occurs, it talks about charges. The very first sentence of the statute says charges made by hotels. But then on the last sentence here, it says, after the comma, when such charge occurs, there must be a charge. And the only way for there to be a charge is that there's some evidence to that charge. And the rule is clearly erroneous by saying that if you have any tangible evidence that there's a charge, it means it's not incidental to the right of occupancy. Judge Webster, I'm sorry, Judge Lewis.
Did you ever challenge the validity of the rule while it was in existence?
That's a good question, Your Honor. We attempted to challenge the rule after it was revoked. And Judge Davis, you were involved in that decision, stating that you cannot challenge a revoked rule. And that makes a lot of sense. Rules are supposed to give guidance to taxpayers. But we as the taxpayer, we're not, technically I'm not challenging the rule here. We're asking for a refund of the tax. And if you say we would have to go ahead and challenge a rule first, it would create so much litigation because you'd have to challenge a rule and simultaneously be litigating the refund issue. So since we're not challenging the rule, we should be allowed to either challenge an assessment or challenge a denial of a refund, which is what we've done in this case. Now, the Brock case, which is in both briefs, detailed in both briefs, was not a rule challenge. What that case was, they got a permanent injunction from a circuit court judge in Jacksonville, and this court correctly indicated that they did not exhaust their administrative remedies, and they should have done that through DOA through a rule challenge, because that was for the whole industry. It was not for a specific taxpayer asking for a refund. They were asking for the entire industry, saying that the rule was invalid. And for whatever reason, they did not continue with the rule challenge case. If you read Brock, the state's going to indicate that Brock should control here, that they, in the decision in Brock, that it held that the rule was valid. Brock was not a rule challenge case. All Brock was trying to do was, or what it did do, and I think it correctly did, saying you have to, if you're going to challenge a rule, go through the administrative process and challenge it appropriately. And in this case, you didn't exhaust your administrative remedies. Therefore, we're going to revoke the permanent injunction that the circuit court judge had ruled. In this case, interestingly enough, in the Brock case, I think it's very specific. In the last two paragraphs, the state constantly cites the second last paragraph, but they always leave off the last sentence. And it says, although statutory construction is ultimately the province of the judiciary, it should be undertaken without first giving the agency an opportunity to explain its interpretation and to create a record of the administrative forum. And that was really what the holding of Brock was. It didn't validate or invalidate the rule that was in place. Now, for us to come back and once a rule is revoked, the department could constantly pass rules and then revoke them. And if a tax is improperly being assessed against the statute, there would be no mechanism. If you required a rule challenge, there would be no mechanism for a taxpayer to have corrective measures or due process to get a refund or to fight an assessment. If I may, I'd like to just reserve, unless there's some other questions, I'd like to reserve the rest of my time for rebuttal.
Thank you.
Thank you.
May it please the Court, my name is Martha Barrera, and I'm an Assistant Attorney General representing the Department of Revenue in this case. I think the point that Judge Lewis was making is one of our major points. And in this case, despite what Sheraton alleges, the rule, the conclusion of law by the ALJ that the rule was contrary to statute is wrong on so many levels, not the least of which being that it was a conclusion of law based on a repealed rule, that it actually invalidated the rule in a proceeding that was not a rule challenge after this Court advised DOA that it did not have jurisdiction to invalidate the rule. The fact that the Department was deprived from doing a rule challenge and from presenting its case in a rule challenge, and this is because this rule was in effect for at least 10 years before it was challenged. The statute was changed in this case, and that addresses the issue about the Department could revoke a rule and then claim that, you couldn't challenge it. But in this case, in this particular case, the statute was changed to impose the tax, and the limited exemption was taken out of the statute. And it took the Department about 2-3 years to actually get to the point where they were revoking the rule. So they had plenty of notice, plenty of opportunity to challenge this rule, and they chose not to.
Counsel, pursuant to the Department's rule, what types of charges for phone service would be incidental? In other words, how would hotels or motels charge for such services if the charges are not separately stated, itemized, or described on the bill?
Well, Your Honor, that's included in some of the findings of fact, and as Judge Webster pointed out, a hotel would actually pay its own phone provider for telephone calls and for the phone service, and that's included in rates. There are rates in hotels that include payment for telephone service, and yet doesn't separately bill it to the customer or the guest of the hotel. It's an accounting issue. The Department, at one point decided that if they went through all the trouble of separately billing, and actually, when they bill, they actually do a surcharge. I mean, a local telephone call doesn't cost $1, but regardless, the Department thought that if they bill separately, then that's something that can be easily captured, and it's not incidental to the occupancy of the Department. And may I point out of the hotel, may I point out that the exemption or exclusion, it's a limited exemption. The legislature in Chapter 202 at the time had said, or 203, I'm sorry, at the time had said that all entities that receive payment for utility services are subject to the gross receipt tax. The telephone service is a utility that includes all hotels and motels who receive payments except for those payments which are incidental. So it is a limited exemption, and the interpretation that Sheraton is making would make every single charge by hotel and by hotels and motels exempt, which is not under the clear language of the statute. It's interesting, they were both arguing clear language, but, their interpretation really ignores the limitation in the statute. The legislature could have just as well said, except for all charges made by hotels and restaurants for telephone calls are not subject to gross receipt charges. They didn't. They went ahead and added that extra phrase. As far as the issue of the rule challenge, you have to understand that the only issue that Sheraton has raised for their refund request is that the rule was invalid. They're not arguing that the rule was misapplied or that they weren't subject to this. They are saying the rule is invalid. So this, even though it's a challenge to an assessment, it's really a way of having the issue of whether or not the rule was valid before this court, and it is the department's contention that that's inappropriate. When you look at a request for a refund, you're looking to see whether or not the tax was paid in error or paid as not, or the tax was not due. And in this case, the finding, which was finally recognized by the ALJ in its ultimate conclusion, was that the tax at the time it was paid was due. Had they challenged the rule, I think the department would have been successful because the definition of its interpretation of incidental charges was consistent with the interpretation of the limited exemption granted by the legislature. It is a rule of longstanding application. It is a rule that was contemporaneous interpretation of the statute at the time that it was enacted, and it is a rule that the department had within the department's province to promulgate.
Counsel, to follow my earlier question, would a charge be incidental only when it is included in a room rate?
Yes, Your Honor. I mean, that would be where yes. The answer is yes. I don't know if there's any other way of charging. At the time that this statute was made and the rule was done back in 1989, I think few hotels were really taking the time to charge for, like, example, local telephone calls. I think that's more prevalent now in the industry, and the times have changed, and I think
because more people are using cell phones.
Well, that's true. And so, we have all this technology and all these changes, and I think there are some changes in the industry where, just about every hotel you go to now has a little placard that says, we're charging. And I think in 1989 they didn't, so that it was an exemption, it was limited. And I think they were more probably addressing this to long-distance calls, for example. But now that there's a charge for local calls, it applies to all the calls which are being separately billed. And when the hotel goes into and takes the trouble to list the telephone call, track the time, track when it's made, and set a charge for it, and advise the guests for the charge, it is the department's contention that that's not incidental. So you have two issues here. I think the issue of the whether or not this rule challenge should really be allowed under the guise of a denial of a refund request challenge is one issue, which we contend that it's inappropriately before this court. And then even if the court wishes to consider the appropriateness of the rule, I would suggest that the department interpretation of that statute is reasonable. May not be the only interpretation, may not be the best, but it is a reasonable interpretation of the limited exemption that was granted by the statute.
On the other hand, counsel, if we were to agree with the appellant regarding the meaning of the statute, wouldn't the appellant be entitled to a refund? In other words, was the ALJ correct in finding that although the appellant was entitled to the exemption, it wasn't entitled to a refund?
Yes, I believe the ALJ, we believe that the ALJ was incorrect. But had this not been...
On the first issue.
On the first issue, of course. On the second issue, we were all happy. But the problem here, I think, is, and that's why this case is so unique, he didn't have to reach the invalidity of the rule. As a matter of fact, he shouldn't have reached the invalidity of the rule. He could have made the conclusion without getting into whether or not the rule was valid.
You're saying he should have approached the case exactly opposite to the way he did.
Yes.
He should have said, you're not entitled to a refund because this was the law at the time, and therefore I'm not even going to consider whether the rule is valid.
Exactly. He did not have to reach that far. And as far as the rule challenge, they did file a rule challenge concurrently with the other case, which is this case, which is the challenge to the denial of the refund, and were foreclosed from bringing a rule challenge. And so by the same token, they should be foreclosed in this case. You know, there's no difference between the two. The rule was valid. It was already held to not be challengeable, and, you know, at that point in time, and thus, you know, the ultimate conclusion is that the tax was proper at the time that it was imposed. The other thing I would like to bring out is, even though it was dicta, I cannot not consider, and I don't think this Court should not take the decision in Brock lightly. I think that at the time they found, and I think the most important part of it was that they found that in that dicta that it was a limited exemption. And if this Court finds that it's an all, that the statute exempts all calls, then it would be going over the negating that section of the Brock decision.
But if it was dicta in Brock, that's really not a problem,
I understand, but, you know, wouldn't be
I have a question I'd like to ask you, because I'm not an expert on tax by any means, and I guess in some ways I'm happy that I'm not an expert on tax. But
I get that a lot.
am I correct in presuming that if the phone charges are included in the room rate, okay,
Right.
that the hotel is being taxed on the room rate, and revenue is being collected from that aspect of it, including, by implication, a tax on the incidental phone item?
Well, it's different. There is a tax
I understand it's a different
Okay.
tax. It's not a gross receipt
receipts,
tax like
yeah.
this, but they are being taxed.
Right, because then the full amount of the room rate is taxable.
Right, but for this statute, charges that are separately identified on the bill for telephone use would not be taxed. Is that right? At least not to the hotel.
If it was a full exemption, it would not be a gross receipts tax, right? It would not, if hotels were totally exempt from gross receipt taxes. You read that section of the statute that says, you know, incidental to as, you know, providing a full exemption, yes, it would not, they would not be taxed.
And that might help explain why, in fact, it says incidental, because the legislature knew that if it was incidental, it was going to be taxed anyway.
That could be true, because it would be part of the room charge, yes. So if there's no more questions, I made I would like to close. Thank you, Your Honor.
Mr. Moffett, you have about 4 minutes and 45 seconds.
Thank you, Your Honor. Judge Lewis, I think you hit the nail on the head when you talked about what about long-distance charges. And you pushed Ms. Barrera and asked her, when would this exemption ever apply? And her indication was only if the charges were built into the room rate. But long-distance charges, at least in the period of time this was in effect, would never have been included in a room rate, because people could go in and charge tremendous amounts of long-distance charges. So unless there's a separately stated charge for long distance, there would be it would have to be identified as a separate charge. Ms. Barrera also indicated that we're challenging the rule. Actually, what we're doing is we're saying we're entitled to a refund under the statute. As part of their denial of the refund, they're saying there was a valid rule in effect, so we are countering that argument, but we are technically not asking for invalidation of the rule. We're asking for a refund under what we believe is a clear and unambiguous statute. Again, Judge Davis, you, with others, indicated we were not entitled to challenge a rule at this point in time. but that doesn't mean we should lose all rights to challenge an assessment or to challenge a refund denial. They keep indicating that this is a limited exemption. First of all, in our brief, we talked about that we don't even believe this is an exemption. We believe that this is the definition of a taxing statute, but that's in the brief, and I'll leave it at that. The statute does have limitations in there. One item is, you have to be required under the provisions of 212 to collect transit rental taxes for these charges, to not be subject to this gross receipts tax. Not all transit rental charges are subject to sales tax under 212. There's exemptions there. For example, if it's for more than 6 months, if somebody checks into a hotel and signs a lease for more than 6 months, they don't have to pay the sales tax or the bed taxes that go along with that. That's specifically in the sales tax rules. So there are circumstances that would apply where these items would not, where the charges by hotels for telecommunication charges, even separately stated, would not be exempt from the gross receipts tax.
Is that true generally, or does it only apply to certain types of hotels that, as a general matter, exist for longer stays?
Well, no. The department has ruled in the past, for example, where airlines have had rooms where they get bulk rooms for their people that work for them, the pilots of the crews.
And they just rent them on a block basis.
And if they say if you rent a minimum of 10 rooms a night for more than 6 months in one day, that would be exempt. But if it's an average of 10 rooms per night, then you have to figure out what's the minimum number that could come out to, which theoretically is 0, because you could have 20 one night and 0 another. I just wanted to get to one last point. The administrative law judge, again, he did go through, we believe his opinion was inconsistent. I think Ms. Barrera indicated she did also, that he found that the exemption, that I don't want to use the word exemption, but that the charges were, charges that occurred were incidental to the right of occupancy. But then he said we were not entitled to a refund. He did, in the record, there was competent substantial evidence. It was stipulated to by the parties. There was a joint stipulation that indicated that charges, the charges in these proceedings were separately stated on guest invoices. And also as part of the record, there was sample guest invoices that were there. So the judge did have competent substantial evidence to make the determination whether or not we would be entitled to a refund under the statute without going and invalidating the rule, by making the determination that those charges were incidental to the right of occupancy. There's no more questions. Are there any questions? We thank you for your time. I'd just like to mention one other thing. I know the Sheraton Bell Harbor has been here a couple times. The hotel is being torn down, so this is probably going to be the last tax case that you hear from them. Thank you.
Thank you both.